Excellent. Thank you, everybody. Welcome back from break. We have one more session, and I think that you will be very, very...
One more session this morning.
I was going to say before lunch, but this is great. This is just like being at home. I don't even have to finish the whole thought. So, well, Donna stole the thunder because there's lunch after this, and then there's another terrific panel, so we appreciate you sticking around with us. There's a terrific panel, one that I've been very excited about. And before I begin even, I want to thank Gary Norman, one of our friends and one of the members of the board of directors, for helping to pull this panel together for us. This is really a little bit of a different tack than where we've been, but a very similar theme. And this was really looking at the intersection of key pieces of law, technology, science, and as many people understand, this is something that has evolved tremendously just in the last 5-10 years, and it continues to evolve quickly. So the issue is very topical, and I couldn't be more happy than to have Amanda Pustilnik and Lydia XZ Brown with us here today. Amanda is a lawyer and a law professor here at the University of Maryland Francis King Carey School of Law, and is a faculty member at the Center for Law, Brain, and Behavior at Massachusetts General Hospital. Amanda's work focuses on the intersections of law, science, and culture, with a particular emphasis on the brain and neuroscience. Amanda's research has looked into models of the mind in criminal law, memory, and evidentiary issues, and the role of pain in different legal domains. Amanda is a frequent speaker on neuroscience and the law, and prior to entering academia, Amanda was a trial attorney and worked in management consulting. We're very excited to have Amanda join us here today for our discussion on science, technology, and justice. And Amanda, I appreciate you being here with us. Lydia XZ Brown is an attorney, advocate, activist, educator, scholar, speaker, writer, and organizer, and that doesn't even begin to scratch the surface. That relates to Lydia's work on disability rights and disabilities justice. Lydia's body of work is dynamic and firmly rooted in educating and advocating about interpersonal and state violence targeting disabled people, particularly those at the intersections of disability, race, class, gender, sexuality, faith, language, and nation. And again, that's not a complete list. Lydia is a regular speaker at thought leadership programs like this, where they share their knowledge and insights on disability rights, disability justice, intersectionality, and neurodiversity. In 2013, Lydia was recognized by the White House Champions of Change program. In 2014, Lydia received the Empowering the Future Youth Activist Award from the Washington Peace Center. Then in 2015, Lydia was named a top thinker under 30 in the social sciences by Pacific Standard, and was included in MIC's inaugural list of the next generation of impactful leaders, cultural influencers, and breakthrough innovators. Then again in 2018, Lydia was awarded the National Association for Law Placement's Pro Bono Publico Award. And again, this is just a small list of Lydia's involvement. So Lydia, thank you very much for joining us today. I'm going to start our program a little different, not with a program right off the bat. What I'd like to do is turn the floor over to each of you to provide us a little more background on you, your work, and how you became involved in the lines of work that you are, maybe your elevating moment. So Amanda, why don't we start with you?
Thanks. I really appreciate the kind introduction and the honor of sharing the platform with you, Lydia. Let's say that the last panel was extraordinary, and on the one hand, a bit of a tough act to follow because I personally would love to still be listening to them right now. But they also provided us with a wonderful jumping off point for talking about issues of science and technology in law, because even though it wasn't their core focus, science and tech topics that they brought up as fundamentally important to their work included CompStat, forensics, body cameras, and facial recognition, as well as the importance of theorizing systems rather than just responding to things that happen within them. Well, the core of my work, and I think very much of Lydia's work too, though I wouldn't presume to speak for you, is that science and technology are very important to understand on their own terms, but also to be theorized insofar as they participate with systems, including systems of justice. And I'll call myself reasonably tech positive, although not tech utopian. That said, every technology that we might hope will fix a problem can only fix the problem if we have thought in advance about the nature of the system into which it is being introduced. So I've been interested in law and neuroscience and the mind-body relationship for a long time, for obscure reasons I'd probably need a psychiatrist to figure out. But my interest in pain specifically grew out of a family tragedy, where I was already working in law and neuroscience. I was already on the path to becoming a professor, and my sister suffered a traumatic injury that created a terrible, really truly disabling pain syndrome. And I saw how poorly she was treated in the medical and legal systems because her pain wasn't matched by objective, quote unquote objective, evidence of tissue damage, like a terrible, visually obvious burn or a limb difference. So I started looking into the neuroscience of pain to see that, pain is not only represented in the brain, not only experienced through the brain, but that there was a new and developing set of technologies, primarily functional magnetic resonance imaging, that shows the brain in activity, not just in structure, and that this functional magnetic resonance imaging, as well as structural magnetic resonance imaging, could really show how chronic pain develops, why it can become so severe in some cases, and how chronic pain can exist in the brain, very biologically, with great biological reality, independent of peripheral tissue damage, in ways that were not being represented in the law, because our disability laws, further research showed me, were grounded in a dual suspicion of fraud. And every government agency that's spending our tax dollars should be a good steward of resources, so there should always be some anti-fraud guardrails, but that this suspicion of fraud went deeper, specifically to suspicion of pain as a sign of hysteria, that it's hysterical women in particular, and sometimes hysterical men, even though, of course, men don't have hysteria uteruses. And that people who appear to have this kind of pain are really just not credible, and that pain is treated differently as a matter of regulation and statute from any other category of biological impairment. And so, being the naive young scholar I was, I thought, well, this is great. I will bring together these brain imaging scientists who are showing the reality of pain. And I'll bring together some people from the Social Security Administration, and they'll just discover that pain's really biological, and they'll fix it. Ha ha ha. Young people, they're so cute. I did work with terrific scientists, and I did work with some terrific policymakers, and the interest that I saw being developed in these technologies was not how do we diagnose pain better, how do we reduce inequities in pain treatment, because women and African Americans on average receive a lot less pain control medication and instead get referred out either for no care or for psychiatric medication when they report the same kinds of pain as their white and or male counterparts. And this is some very well-controlled research, and I'd like to give a shout out to Diane Hoffman here at the University of Maryland, who's done a bunch of this work too. Actually, for many years, from before I was here. There are so many positive ways of using brain imaging technology to update or inform legal doctrines, and yet the interest that seemed to emerge was, well, how do we root out fraud? Now maybe we can use brain snapshots to figure out who's engaging in fraud. Maybe we can put these machines in emergency rooms to root out drug-seeking behavior. Or maybe, and so the Social Security Administration has, in the last few years, put out RFPs for handheld painometers that they could give to their adjusters to try to figure out whether cases are legitimate or fraudulent. And so pain has many cultural significations. Pain is almost never just pain. And so it can make, it's an important set of issues or problems in itself, but it can also frequently show us as a kind of sentinel case of the ways that certain issues are translated in society. And this is a perfect example of how there's a biological reality, there's a set of legal issues, there could be one set of matches between them, it's not necessary that it goes in one direction or other, but it's still the weight of institutions and processes, very much to what Alec and Michael both were talking about in the last session. The weight of institutions and processes will absorb a new technology consistent with what the institution's preferences and policies have been all along. And that if you want a new technology to solve new problems or to solve a same problem in a new way, it's very important to think in advance about how the technology will be integrated into the system. Very much the same with forensic technologies. And I'll give a shout out here to my amazing colleague, Menka Singh, who's doing really wonderful work on forensic integrity. That we should all be in favor of good forensic science. And certainly beats technically flawed or corruptly practiced forensic science. And yet, in Menka's work, she's done a great job showing that institutional practices around policies and procedures and around who has access to technology and to justice will continue to use new technologies or improved technologies to, in many cases, reproduce the same kinds of problems. I'll cede the floor in just a sec to Lydia. I also just want to briefly mention that, of course, science and technology goes well beyond criminal justice and beyond disability. Brain-computer interfaces are another area of rapid development for criminal law, civil law, ethics, and commercial law. And if folks want to talk more about brain-computer interfaces in the Q&A and invasive and non-invasive systems that engage in artificial intelligence-assisted translation of brain signals and what that can mean for privacy, autonomy, and cognitive liberty. Also, something that I think, an interest I think we share. Would love to talk about that too. Thanks.
Thank you, Amanda. You've got all these buzzwords coming in that I want us to talk about every one, and hopefully we'll bring it back because I want to know if your pain-o-meter is as reliable as maybe a lie detector. We can find out how that works. But before we get there, I do want to turn the floor over. Lydia, we'd love to hear about you and your background, and I understand you're making a career move. Maybe you can fill us in on that a little bit as well.
Sure. Hello, good morning. Is it still morning? Is it now afternoon? It might be afternoon now. If it's before 2 p.m., I think it's morning, chronically. You were talking about your early conversations and your youthful naivete with the Social Security Administration. It reminded me that I have been receiving an increasingly frantic number of emails from some of my colleagues at SSA this week because I'm working with them on a project right now addressing some of the systemic determinants of ableism in their eligible determinations process. And I was thinking about how earlier this week when reviewing those emails, I was asked, in order to be compensated for your services, you need to fill out this form and submit it back to us so that we can render you payment. And I remember thinking, I don't want to give you my Social Security number. And then I was like, wait a minute. This is the Social Security Administration. They already have it. I guess they can have my number again that they assigned to me. So, thank you for reminding me to take care of that little bit of administrative paperwork in my clearly non-caffeinated brain, thinking about that. So I am joining you today on my very last day as a policy counsel on the Privacy and Data Project at the Center for Democracy and Technology. And on Monday morning, I will close one laptop and open another as Director of Public Policy at the National Disability Institute. So that is my weekend career shift in the middle of COVID. Close one laptop, open another. And if you'd asked me at the beginning of this year how my year was going, I would have told you, well, it is simply stressful. I spent most of 2022 digging out of the rubble of having run for the Maryland state legislature. And so for about a year, my friends didn't even hear from me unless I was asking them for money. And now I'm like, oh, right, I had a social life pre-2022. I would like that back. So that is where I am now. Now, we're gathered today to talk about emerging issues in the field of science, technology, and intersects of law. And when I am asked about what my work has looked like, I usually begin by explaining that for the past few years, I have been focusing in particular on algorithmic discrimination, or ways in which automation and artificial intelligence-informed applications help to enable, exacerbate, and accelerate existing forms of systematic and structural discrimination. And my work has focused in particular on the ableist impact of automated and algorithmic technologies. And that is to say, in thinking about disability discrimination as a form of what is sometimes called systemic or structural oppression, which is that ableism is not simply individual values and beliefs that individuals may have about the perceived worth of people with disabilities or people's capacities based in their physical or mental attributes, but that those values and beliefs are embedded into a system of structures and relationships that are about power. In much the same way that we must bring that analysis to bear when we think about racism as existing beyond merely individual animus, but also encapsulating systems of power. And so my work has focused, as it has for the entirety of my career, on the particularly devastating impact of algorithmic harm on disabled people who are at the margins of the margins. So for instance, when we think about increasing surveillance of beneficiaries of public benefits, such as Social Security benefits, or access to Medicaid-funded long-term supports and services, or access to food stamps, those surveillance practices predate modern technologies. And when we talk about surveillance technologies now that may be further enabled by automated functions or algorithmic functions, those technologies exist to simply accelerate and make more expedient analog practices that existed prior to the development of algorithmic technologies. Those technologies exist, as my colleague was just discussing, right, to underscore and to perpetuate and to reinforce existing public policy objectives and societal values. For example, in the focus on fraud, that disabled people are presumed to be necessarily engaging in fraud if seeking to become claimants of any form of public benefits. And that perception is all the more exacerbated if the disabled person in question is a Black and brown person, is a low-income person generationally, is somebody from outside the US who does not hold US citizenship, that every vector of further marginalization accentuates the prevailing belief embedded into the design and structure of our social services system that that person must be presumptively engaged in fraud unless they can prove otherwise. And if not fraud itself in the sense of lying, that they must be somehow undeserving, that they are not sufficiently deserving of this public benefits program, whatever form that benefit might take. Now, at the same time, if we think about surveillance technologies in other capacities, they too exist to reinforce existing public policy objectives. Whether we're talking about surveillance technologies embedded in the classroom, over the last couple of years, we've seen in COVID-19 that whether in K-12 schools or institutions of higher education or our beloved bar exam, that's sarcasm. I have very traumatic memories of the convention center downtown. Recent ones, unfortunately. Whatever form of test-taking administration we are describing, we now know that over the last few years, that virtual test proctoring companies, some of which use automated software, and some of which do not, they simply use remote proctors that might be observing a test taker through a webcam, which frankly is also creepy, in my opinion. Very non-technical term there, creepy, right? That these technologies seek to reinforce existing policy objectives, which is to attempt to control for unauthorized activity defined as some student doing something we think they shouldn't be doing. And if you're limiting that definition to, we don't want students cheating, okay, sure, we could stop there, but we could also dig a little bit deeper. What are the reasons that students cheat? There's actually a whole body of psychology research on the reasons why students cheat in schools. And students are cheating, firstly, they want to get a better grade, right? Like, I see you laughing, right? Like, they want to get a better grade. Who wants to get an F? Who wants to be the one student that's failing your exam and then you have to tell your parents you failed this exam? Especially students with certain kinds of parents, and I know that some of you relate to this. You don't want to be that one who has to bring home that bad grade. But students might cheat because they are not actually being afforded an education that is about the substance of the material they're learning. They're not being taught to synthesize, apply, and transfer knowledge. They're being taught to aim for higher scores and higher grades. And in a system that rewards and incentivizes having the highest GPA, the best letter grades, that tells you consistently that what you have learned can only be measurable in strictly quantifiable terms, of course students will be motivated to cheat. That's why they're cheating. If they're cheating on standardized tests like college admission tests, it's because they want to get into a better college. Why? Because everybody is telling them that every college exists on a hierarchy and that they will be shamed and, depending on your family, perhaps disowned, depending on what you do and do not get into. I've had some conversations recently with some high school students that were frankly horrifying and utterly disturbing. And we are really screwing with children's minds now. Now, we think about the law enforcement use of predictive technologies and predictive policing, which I heard the last panel had a robust conversation about. Again, these technologies do not exist in a vacuum. The people who have always been targeted for harm by systems designed to reinforce existing power relations will continue to be targeted for harm. And so when I think about the growth and explosion of new technological applications and our, frankly, dearth of sufficient legal regulations over their operation, their development, their deployment, I think about the ways in which these technologies are less creating new forms of harm than they are creating new ways of enacting the same harms that have already existed in our social, legal, economic, and cultural spheres. I think about the ways in which new technologies can enable the same harms to exist, but at a mass scale, at a speed, a scale, and a scope that was not necessarily possible before. I think about hiring discrimination. I know, as a person with a disability who is openly a transgender, non-binary person and a person of color, that there are ways in which I have been systematically disadvantaged in seeking certain forms of employment. And there are other ways in which I have a lot of advantage. I've got a law degree and a law license here in Maryland. Also, as of this year, now I am also licensed in the District of Columbia. I get sworn in next week, and I need to remember to register to show up. All right, so that's two things you all have helped me remember today. Contact Social Security Administration to remind them of the social that they gave me, and tell the DC Bar I am, in fact, showing up for my swearing in. Thank you very much, helping me out here, collegiality in action. So there are ways in which I hold privilege when I am part of the workforce, and there are ways in which I do not. But prior to the introduction of algorithmic and automated technologies, if an employer was discriminating against me, it'd be a very individual, interpersonal situation. I have applied for this job. You saw the weird initials of X and Z, and you thought, I don't know if I'm going to feel comfortable with this person being in the workplace. What if they don't speak English? Classic racism. I don't get hired. Or I met this person, they struck me as interesting, but kind of off, because whether or not they knew that I am autistic, I don't strike people as neurotypical. And so they're like, I don't know if other people will feel comfortable with this person in the workplace. We're not going to hire them. Individualized discrimination. With the rise of automated technologies, this happens at scale. You've got thousands of people applying for a job. There is no individual human saying, I don't like that person because their name codes as Black or their name codes as Muslim, or I suspect they might be Jewish. You instead have automated software making determinations that can remove themselves from accountability by disguising how they operate, often through black box algorithms, and by allowing employers and hiring companies to evade that accountability by disclaiming any involvement in the process and providing a veneer of objectivity and neutrality for plausible deniability, so that when the software replicates patterns that already existed, you can't prove necessarily that discrimination took place. But one study showed, and I promise I will stop talking in just a moment, that, for example, one resume screening algorithm that was used at a very large company used as training data to shape its decisions in predicting which future applicants would become successful based on past employees' trajectories within the company. And that algorithm identified as the two characteristics most likely to predict future success, get ready for this, having the name Jared and having played lacrosse. Now, I read this, right, and my reaction was,
That sounds rich and white. So when we think about algorithmic technologies now, I want us to be very deliberate in our framing. We are not talking about wholly new categories of harm. We are talking about new ways of enacting, exacerbating, and accelerating existing harms and harmful public policy objectives.
Well, I'm not sure people want you to stop talking. I am going to give you a minute to catch your breath because I would like to come back to you in a moment because I think we'd like to know there are these risks inherent in this technology that is being developed and deployed so rapidly. How can those be used for the benefit of society? So I want you to come back and see if you have some thoughts on that, but I want to touch base on this because, Amanda, you have a lot of work in this area of technology as well. And you've used this, dealing with all sorts of challenges that come from technology, but there are some successes as well. And I'd like to see if you can explain to us what some of those challenges are. I think Lydia's elaborated on many of them. Maybe give us an example of what some of the successes are. And in your work, you talk about three key issues, three key concerns of privacy, consent, and anti-discrimination. And this is a very interesting topic, and it sounds like it relates to this, so maybe you can elaborate on that as well.
Sure, thank you. And it sounds like you're closer to my recent work than I might be. So I'm going to go back to pain as an example, and then I'll talk about a little bit about juvenile development and drug addiction. And these are all cases where we could look at success of bringing science and technology into law, in addition to being cognizant of the risks. So we don't have a brain-based painometer that can perfectly tell how much pain a person is in an individual case. And if we did, it might be used in a way that is adverse to claimants' interests to try to disprove that they need medication or disprove that they qualify for benefits. But what we do have now is about 25 years of really good brain imaging science showing the reality of pain, showing that chronic pain conditions have a predictable biological life course and, in effect, signature on a group average basis. And this has been used successfully in courtrooms and for settling an untold number of cases to show that people who claim pain ought to be viewed differently. And this is good science that is pushing back against the 200-year-old narrative of hysteria. So if we're thinking in an evidence law context, you would all be familiar as courtroom lawyers with the difference between a framework evidence expert or a subject matter expert versus an expert who gives an opinion about an individual case fact about a claimant. So it's possible now to have a background expert or framework expert come in and teach the jury or teach an arbitrator about the biological reality of these kinds of conditions, even if they can't say that this particular person has it. And this has really changed decision-making across a large number of cases and has even caused the Veterans Administration to change the way it deals with veterans whose chief complaint is chronic pain. Similarly, the science of juvenile development has been having, it has a mixed impact, but is increasingly having an impact in understanding, helping us understand better how teenagers in particular develop, the predictable challenges they have in decision-making, and most specifically, perhaps, why it's a terrible idea to transfer juveniles to the adult system. If we can neurologically understand adolescence as a critical period for acquiring social language in the same way that early infancy is a critical period for acquiring spoken language. You know, little kids, if you don't expose them to spoken language before a certain age, they cannot acquire it. So it's a very neuroplastic period specifically for language acquisition. The adolescent brain goes through a similar critical period for social function acquisition and for becoming the kinds of people who are adapted to the society in which they live. So the incredible emotionality among adolescents isn't just a bug, it's a feature, as is the norm testing. However, if you then incarcerate adolescents with adult criminals or put them in highly punitive environments, that's the social language they learn in punitive, in this critical period. And so it's finally a neurobiological explanation for why kids who are punished more harshly recidivate worse. When you think, oh, they should have learned a lesson. No, what they've learned is they've learned how to pattern their behavior on criminals. And so neuroscience is having a real impact in the discourse on juvenile incarceration and particularly felony murder. And we're all familiar, I think, with the transition that has happened over the last couple of decades with viewing diseases of addiction, including behavioral addiction, as brain disorders and a reduced punitive approach. But in terms of privacy, consent, and anti-discrimination, that takes us a little bit more to concrete neurotechnologies. And there's a whole field of devices under development currently that you may have heard about, some of them in the news, called BCIs, or brain-computer interfaces, sometimes called BCIDs, brain-computer interface devices. These can either be implanted devices, or they can be non-invasive, like headsets. So an example of an implanted device might be a Parkinson's deep brain stimulator. And it's what's called a read-write device. It takes data, an implanted set of electrodes, take data from the brain and interpret that information using computing at the source in the body. It's called edge computing. It doesn't have to go up to the cloud or to a central repository. It happens where the patient is in their device. And then, based on the information the system is reading from the patient, it can customize the impulses it sends into the brain and what kind of pattern of stimulation that person needs. So this can be a profound enhancement to a person's quality of life. And even if it doesn't increase their lifespan, it increases their health span. I'm working a little bit with a company that makes a different kind of brain-computer interface device. It is geared toward reading neurological impulses so that people who have total paralysis or locked-in syndrome can communicate and have some, at least minimal control of their environment. Maybe power a power chair or an artificial arm that could be used to feed themselves, or turn the lights on and off, or translate thought to text using mental impulses. This uses an implanted system. It reads information, and then it transmits that information to peripheral units that then perform the appropriate function, like turn on the lights. Could also be a tremendous enhancement to quality of life. At the same time, there are concerns, legitimate concerns, about privacy, consent, and use cases. Who gets to, so of course nobody would want a device implanted in their brain without their consent. That consent should be fundamental. Consent can sometimes be a problematic construct because consent may be within the universe of excessive constraint, so consent isn't meaningful, but let's say we get good medical consent for this. But consent alone doesn't take care of privacy. Once a person's brain data is outside their brain, it can be translated into all kinds of inferences about them. I may be able, using artificial intelligence-based algorithms, to look at patterns of brain data produced by an individual and not just know that they wanted their power chair to turn left, but also know that they are 2 weeks away from a manic episode, or that they also might be demonstrating symptoms of a future cognitive decline, or numerous other sources of information about the person from incidental data that they may not even know about themselves or that they may not wish to be known. The market for implantable brain devices is probably small, so that's probably not a large-scale social consideration, even though it would matter to the people who have them. But consumer brain-computer interfaces are increasingly prevalent. These are just headsets, and you can put them on for fun, for meditation, for sleep, for controlling gaming systems. You can fly a drone with your brain, which looks like loads of fun. I think up and it goes up. Who wouldn't want to play with something like that? I know I would. But the companies that are developing these systems are not medical device manufacturers. They're not covered by HIPAA. They have no privacy obligation to their customers. And data is gold, data is oil in the new world. So what is happening with the brain data that can and increasingly will be collected by these consumer devices? Maybe they're used just to refine the game, maybe that's okay. Maybe it's sold to create increasingly sophisticated consumer profiles that offer you what you want before you even know it. And this is where consent becomes really inadequate, because it's not medical consent, it's click-through consent, in the same way that when you download an app on your phone or you start using your Microsoft software, we all just click through and we all agree to the EULA. But how can any of us meaningfully consent to the use of our brain data when we may not understand ourselves what's being collected and what it possibly could be used for? So I think that standard contract consent really falls apart for this type of very personal information that has unknown potential for exploitation. We can't consent to what we couldn't know. And so I think this is an area where lawyers have some really interesting work to do, advising companies and thinking about the ethics of these types of devices, so that we can help advise not just companies, but also legislators about the kinds of frameworks that we ourselves would be comfortable with as consumers and users of these devices. Sorry to talk so long.
No. Are you suggesting that in a room full of legal professionals, people are not reading through the terms and conditions on their apps? How could that be? Lydia, your thoughts?
I might be the only person who is stubborn and annoying enough to read every word of the terms and conditions of everything I open.
I'm so impressed.
And I mean, when I was signing the papers for my mortgage, I think I really annoyed the seller's attorney just sitting there. I was like, hold on, I'm gonna read every page of this. I haven't seen this document before. And they were like, it's 300 pages. And I'm like, I know. Just sit there and wait, because I am that person. Now, the question that you asked was, what possibilities do technologies have to promote a more positive outcome societally or for individual people in whatever circumstance that might be? And in contrast to Amanda's discussion earlier, I am not a techno optimist or even close to one. I'm probably more of a techno pessimist, right? Like that might be the best way to describe my approach to thinking about technology. And it is precisely because I understand and recognize that technologies do not exist in a vacuum, right? Who develops them, for what purpose they are developed, both their intended use as well as the public policy objectives that they might exist to further, and the societal values that surround the people who are making and using and interpreting a particular device or program's capabilities. Those don't disappear simply because a computer is involved or software programming. There's code involved, right? And so when we think about technologies, it would be a mistake to think about the development of new technology as somehow devoid or removed from social and cultural conditions and existing decades of jurisprudential decisions about, for example, disabled people's decision-making capacity. That creating a new technology that might implicate whether or not a person is legally determined to be able to give consent, that determination does not rest upon the construction of the new technology, like the brain interface device that you're thinking about, but it also rests upon decades of decisions that have determined whether disabled people in what conditions or in what sort of situations should be able to exercise autonomy over our lives, in what situations guardianship should be granted, in what situations a determination that a person should be subject to commitment involuntarily to a psychiatric institution for 6 to 12 months at a time should take place. Like that body of jurisprudential authority does not disappear simply because there is a new technology that is introduced, and neither do societal and cultural values and beliefs about disability or about gender or about race. They do not disappear. So when I think about how technologies could perhaps benefit people in general or marginalized people in particular, I want to turn that question on its head and ask instead to the people who are regulating technological development and deployment, and to the people who are researching and developing new technologies, who are you building this for? Who is designing this? Whose priorities, whose needs, and whose objectives are actually determining the trajectory of this R&D process or the regulatory proposal? are the people who have the most to lose if this goes wrong, the ones who are setting the policies or who are setting the parameters for the research? Are you engaging in an iterative process with the people who are the most directly impacted by this type of technology, for better or worse, as you continue to develop this technology, or as you continue to refine a regulatory framework for, say, protecting our privacy? You may or may not know, if you are not paying close attention to privacy law, this might be outside of your purview, or maybe it is. I do not know all of you. We don't have comprehensive privacy protections in the United States. We have a patchwork of regulations and laws with different levels of effectiveness and different types of protections for some data that exists in some forms that is not complete. Like you just mentioned HIPAA, for example, that for-profit corporations developing brain interface devices are not covered by HIPAA. Well, here's the thing. Medical information is not necessarily covered by HIPAA either, right? It applies to who holds the information, not the nature of the information. If you've given your most detailed medical records to your local gym or your neighbor, I don't know why you would, but say you did, they are not protected by HIPAA. HIPAA protections do not apply, right? We only have a patchwork of regulatory authority because we don't even have comprehensive privacy regulations here in the United States.
Oh, can I jump in with the CPAP example?
I mean, I am enraged about this situation as well because my partner and my best friend both have a CPAP, right? Are we thinking about the same thing?
I think so.
The CPAP that is like, connected to an app,
Yes,
and then
and
it's
the
collecting all your
insurer-
data?
Yes.
Yeah.
Well, then maybe you should talk about it, because I only know about it as an issue, not somebody who's lived through having the problem.
Oh, no, so like my best friend literally says to me upon getting this new CPAP device a couple years ago, so I got all these instructions that said I need to download this app to my phone, so it's gonna collect data on how many hours of CPAP therapy I'm getting every night, and like what the pressure level is, and how many incidents of sleep apnea I have every night, and then my insurance company has it, and my doctor has it, and like, you work in privacy issues. Is this a problem? Should I download this app? And I was like, no! Like, imagine that meme going, no! Like running to grab the phone and like, do not. And anyway, spoiler alert, it works fine without the app collecting and transmitting this, frankly, highly sensitive data to who knows where.
Well, and so there's additionally a science and tech reporter who had a CPAP. He
Right.
downloaded this app. The information was going to his insurer. There was a software update, so a glitch in the software caused the app to stop collecting the hours correctly. His insurer made the determination he was not using the device as prescribed and
Would stop covering it.
stopped covering it and remotely shut it off. Yes. So, one of the questions that had come up around this incident was, but isn't this health data covered by HIPAA? Isn't it private? No, when your insurer is funding something, they are allowed to get all of the data and use it within certain constraints. They can't just sell it on to third parties. But the insurer made the determination that he was non-compliant and therefore stopped paying for it, which shut it off.
Yep.
So when you talk about around whom, now I'm being the tech positivist, I'm looking at the tech as the CPAP is great, and it's great to have feedback between the patient and the provider, and maybe you send them a nudge. Hey, it looks like your CPAP isn't working or you're not using it. What's your health situation? That could be great. That's the optimist part. And then the situated institutional sociological perspective is, and for whose benefit is this being done? Is this patient-centered?
Is it
Is
really
this-
for the bottom line of the insurance company?
Is this ethical? Is this life-respecting? Is this being developed in an iterated way with all stakeholders involved? And the answer is,
And do the patients have the meaningful
Yeah.
autonomy to decide, I want my doctor to have this information? And
Precisely.
to change their mind.
Right.
And to say, and I don't want anyone else to have this information.
Yeah.
I don't want the insurance company to have it.
Right.
for
And so,
example.
speaking of reading the 300 pages of your mortgage, the nitty-gritty for whether technology is oppressive or liberatory can really be in things like the terms and conditions of a user agreement drafted
Which
by
are
lawyers.
not regulated.
Yeah, right.
And
Well,
some
I
of them
think-
are abominably bad.
I think we've just scratched the surface, and I didn't tell the both of you before we started that we had asked people to silence their cell phones, not use them. But I think through your discussion, I just saw 5 people delete their apps. So David, you were one of them. So don't,
Just for effect.
So
Haven't even-
I feel like we've barely even scratched the surface. I have no idea where the time went, and I did actually check my watch this morning. It is working correctly.
Talk about how
But-
in Florida, there's even one county, right, that their sheriff's office is cooperating with the local schools, the local education agency, to collect data to predict which children would be more likely to potentially commit crimes and therefore should have greater interventions in their lives. And the data points that the school district is sharing include attendance and if they got grades of C or below, which necessarily creates discriminatory conditions against lower income students who have less
Or
support to be able to
non-English speaking.
succeed, non-English speaking students, disabled students, and especially if they are disabled or low income or immigrant students of color, right? And yet this is literally creating Liam Neeson's movie, but in real life and for children.
I want to see if it's. I know that we had discussed possibly having a couple of questions from the audience. I have to assume that there are numbers. So I will turn it over to the audience. So please, Kevin.
Thank you. This is very informative. And again, we could be here till the cows come home. But back in the Stone Age of the Clinton administration, when the genomic sequencing was discovered or completed, there were many, many concerns about the ethics of if you have this gene, you have a gene marker for this propensity and everything else. And that was 1,000,000 years ago. And I'm just wondering, as we go up exponentially with algorithms and AI and everything else, there is a potential for great benefit, but there's, I think, a worse potential or a greater potential for abuse. And the question is, as lawyers, we don't want to shut things down because we want to have the benefit of it, but you have an optimist and a pessimist. So what do you think we do from here, or for 10 years from now,
I'm
maybe?
glad you mentioned genetics, and I'm glad you mentioned the Clinton administration. So we have GINA, the Genetic Information Non-Discrimination Act.
Yes.
And GINA is, if we were going to rewrite it today, like all lawyers, I'd probably want to take a pencil to it. But it's a really good framework in many ways for limiting employment discrimination and insurance discrimination based on genetic information. I think, for years I've been meaning to write this paper and haven't yet, I think we should have a NINA, a Neuroscience Information Non-Disclosure and Non-Discrimination Act, based on GINA, but going a little farther in certain ways, so that neurotech can develop, can be used, but that there are certain guaranteed privacy protections and limitations on use. Like an employer, I don't think anybody should be using IQ tests. They've long been debunked for their predictive
There are
utility.
employers still
But I
using
know
them.
there are an employer gave me one. It was so insulting. We might not be able to stop employers from doing sort of useless and stupid things like IQ tests, but we should be able to prevent them from using things like EEG. So I think that some of the work on genetics provides a terrific template. Thanks for bringing that up.
And the proposed American Data Privacy and Protection Act, which failed to pass last Congress but will be reintroduced this Congress, also designates any information that could be used to assess, evaluate, predict, or guess at, or that is data related to a past or current or potential future mental health diagnosis, physical condition, or other disability-related information is designated as particularly sensitive and subject to additional protections around collection, retention, storage, use, sharing, et cetera. But that proposed bill also only covers certain entities. It is a fairly wide-reaching bill because it covers largely commercial entities, right? But that type of language would also strengthen our regulatory patchwork significantly.
Thank you. I see. Yes, sir.
Really quickly, I haven't heard you talk about accountability. If you have people with these brain devices receiving impulses, the other part is, what does the jurisprudence say about that? We deal with this issue with people around the question of capacity. Did they know what they were doing when they did it? Et cetera, et cetera. i.e., Atkinson in Virginia, kind of stuff. The other thing is that how do we get lawyers, right, to the point where they understand the technology and the science so that they can write the laws and, go into the courtroom and deal with this? Thank you.
Well, in the second half of that question, we have a lot more educating to do. I know that there are increasing numbers of law schools that are offering courses on technology alongside law, and that some of them are doing so with a specific focus on integrating actual CS, computer science focused information into the curriculum as well, so that the students who are taking those classes come out with more of a granular understanding of how such technologies might work, rather than just simply being like, oh, technologies exist, but I don't know how they actually operate. But you're right, there's a very clear disconnect. And most people that I speak to in my work either have a really clear, nuanced understanding of the legal framework, but very little technology-specific technical knowledge, for lack of a better term, or they have a very clear and deep understanding of how a certain technology or classification of technologies operate, but they do not have an in-depth understanding of legal frameworks. They don't have, it's not their training, it's not their background. So there's a clear mismatch, and I don't think there's a quick or overnight fix to that problem, but by integrating education between schools that are training future programmers and developers and schools that are training future lawyers, so that those who are interested in this nexus of law and of everyday life and technological mediation of everyday life will develop those competencies. But I think there's also an opportunity, for example, for MSBA and other entities to provide that kind of hands-on education, perhaps in partnership with technology justice focused organizations and CS schools, so that lawyers who are now encountering these issues for the first time in their practice can develop a bit more of that competency. And if any of you are thinking about that type of programming, I would be happy to help facilitate those connections too.
I'm going to say challenge accepted and offer accepted.
You're welcome.
So I think we have one more question, and so please.
Good afternoon. I'm an administrative judge with the Social Security Administration. So in evaluating disability cases, pain is a really tough issue.
It's so hard.
Right. But the disability decision has to be based on the administrative record. It has to be supported by the record. So I was wondering, in evaluating pain, could AI be used to look for behaviors in the record that would support the claimant's allegation of disabling pain?
This is such a great question, and I'm thinking in two directions. One is generally the use of AI for streamlining the onerous work of going through a large record.
And I'm going, no.
And I want to hear why. But I'll be the naive techno-utopian, and then you'll bring us back to earth. Because, and I don't know the extent to which different branches of state, federal, and administrative judiciaries use document review technologies. But when I was an associate and I had to review potentially, or I was parts of teams that had to review hundreds of thousands or even millions of pages of documents, using, at the time, 15, 20 years ago, very primitive software to at least do a first cut was extremely helpful in, I'm sure, missing documents, but also finding the hot documents, and then using human review to extract patterns and to check whether. So I expect that there probably is a really productive, imperfect, but probably productive use of technology for developing what are the types of profiles of behavior or lack of behavior that we would expect to see, and are we getting evidence in this case in a very large record that roughly conforms to that, and that it's not giving a final answer, but it's giving you a shortcut so that your job is more efficient and easier and gives you a kind of a digest, like Reader's Digest to this case. That would be fantastic. I don't have the CS background or the practical background to know if the evidence could be digested in that way, or if patients' records are even that standardized in disability cases. I would say, though, that in your question you spoke about behavior, looking at behavior, and that is so critical, because behavior is usually the best tell for how a person is doing, and changes in behavior. If a person used to be really active, then they claim an event happened, and now their behavior and their life activities are substantially different, that probably tells us more than a brain scan or an interview, a one-off interview by a medical reviewer or expert who spends an hour with the patient and doesn't have the full 360 of their life. So I commend you for looking at the behavioral information and the life activities in addition to the medical data. And I'm sorry I don't have a more comprehensive answer.